Good afternoon, everyone. I'd like to welcome you to this afternoon's presentation, our 2020 Year in Review Labor and Employment Law. My name is Kathy Purdy. I'm a marketing manager at Bond, Schoeneck King. Just a few quick housekeeping items before we get started. Please enter your questions through the Q&A box located at the bottom of your screen, and we will do our best to address those as time allows once the webinar presentation itself has finished. If you would take a moment and complete the survey that you receive as soon as the webinar is over, we would appreciate that. Our attorneys they look at your answers and appreciate your suggestions for future comments and topics. This program's been approved for 1.0 of Sherman HRCI recertification credits, and you'll receive those via email after the webinar. Today's presenters are Lou DiLorenzo, Kate McClung, and Joanna Silver, all members in the Labor and Employment Law practice here at Bond. So to start things off, I'm going to hand it over to Kate McClung, who's in our Rochester office.
Great. Thank you so much, Kathy. I'm going to start off by talking about some of the new COVID-19 leave laws that we got in 2020. Next slide. So the first one on the federal side was the Families First Coronavirus Response Act, which was passed in April, and it did in fact expire at the end of December 31st. That was the expiration date in the initial statute. Congress did not extend the requirements under the statute, but they did extend an option for employers to continue to provide the leave through the end of March and receive the same tax credit for doing so. But that is voluntary. Employers are not required to provide leave under this statute in 2021. If you are considering taking advantage of this voluntary extension, there's some things to keep in mind. First of all, it's subject to the same eligibility requirements. So it's still only available to private employers with less than 500 employees and certain public employers. There's still the same exceptions for healthcare providers and first responders, and limited exception for small businesses as well. Just as a quick recap of the statute, there were two main types of leave: emergency paid sick leave, EPSL, and emergency family and medical leave, or FMLA. Next slide. The EPSL, if you do the voluntary extension, keep in mind it is still the same 80-hour bank. So if an employee has already used up their 80 hours in 2020, then they've used up their hours. They can't take any more in 2021, even if you pursue the voluntary extension. It's still subject to all the same qualifying reasons, which are listed here for your reference. As Kathy mentioned, we are going to be circulating a copy of this presentation, so you'll have reference to these. Next slide, please. It's still subject to the same cap amounts as well. There were different daily and total cap amounts depending on the reason they were taking the EPSL, and employees would still be immediately eligible for this upon hire if you choose to use that voluntary extension. Next slide. The emergency FMLA leave, again, same qualifying reason where the school's closed, the child care provider is not available. The first 10 days would continue to be unpaid, and there are caps for the amount of the 10 weeks that are paid. Some important things to note if you're considering extending this into 2021. This emergency FMLA comes out of the same 12-week bank as traditional FMLA. So employees can't take more than 12 weeks of EFMLA and FMLA combined in any 12-month period. There is also a cap on the amount of emergency FMLA that someone can take total, which is 12 weeks. So even if you're looking at different FMLA 12-month periods, there's still a cap on the total amount of emergency FMLA that an employee can take. So some important things to keep in mind if you're going to extend this for your employees. Next slide. Some common mistakes that we've seen with the FFCRA, and it's not too late to correct these if you've made any of these. First of all, failing to get documentation from employees. The FFCRA is a tricky statute because on the one hand, you get to claim a tax credit and get reimbursed from the IRS. But if you mess up the amount and you overpay your employees, then you can get in trouble with the IRS for taking more of a tax credit than you were supposed to take. But if you mess up on the other end and underpay your employees, the FFCRA does provide for a class action mechanism for employees to bring claims. So it would just take one employee to bring a claim on a class action basis on behalf of all the employees that you've goofed up for. So it is important to make sure that you're getting things right. And as I mentioned, it's not too late to fix things retroactively if you need to. So first of all, failing to get documentation from employees, the IRS has said that the tax credit is dependent on you being able to substantiate your eligibility for that tax credit. They've spelled out the information that you should get in case they ask for it. So some general information you need is the employee's name, the dates for which leave is requested, qualifying reason for the leave, and an oral or written statement that the employee is unable to work or telework for that qualifying reason. Some specific qualifying reasons require additional information that you need to get. So if someone's taking emergency paid sick leave because they are subject to a governmental order of quarantine, you need to get the name of that governmental entity that issued the order. If they're taking emergency paid sick leave because their healthcare provider told them to self-quarantine, you need the name of the healthcare provider. If they're taking either type of leave due to childcare or school closure issues, then you need the name and age of the child, the name of the school, or the place of the child care provider, and a representation that there's no other suitable person available to provide that care. So it is important to get that documentation. A second common mistake that we've seen is paying the wrong number of hours. The number of hours include overtime hours, although you don't have to pay an overtime premium for those hours. You need to look at the employee's normal schedule. If they don't have a normal schedule, look at a 6-month average of how many hours they work per week. If they haven't been there for 6 months, then you look at how many hours you and the employee agreed that they would work upon hire. And if there was no such agreement, then you take the average hours for the entirety of their employment, which is less than 6 months. So sort of 4 steps to go through in determining how many hours that you need to pay an employee. You can't just assume, oh, I'm just going to pay 40 hours a week, because a lot of employees, that wouldn't be the right amount. Another issue we've seen is not paying the regular rate. A lot of employees may make an hourly rate, but they may get other types of compensation that go into the regular rate as well. So consider shift differentials, non-discretionary bonuses, commissions. There's a lot of other things that may need to go into that regular rate calculation. This is the same regular rate that you should be using for your overtime calculations for your non-exempt employees. There's other ways to incorrectly calculate the regular rate as well, because keep in mind, a lot of employees, the regular rate changes from week to week. So what regular rate are we talking about? And you're supposed to use the regular rate for a period of up to 6 months prior to the first date that the employee takes leave. Or if the employee hasn't worked for you for 6 months, then the average regular rate for the entirety of their employment. Once an employee has taken this leave once, if they've already worked there for 6 months and you do that calculation using the 6 months average, if they subsequently take leave, you can use the same regular rate from that first calculation. You don't need to redo it. Finally, another common mistake I've seen is not claiming the full tax credit. And this is one that won't get you sued by anyone, but it might mean that you're not getting all the money that you're entitled to either. So for this one, make sure that you're getting the wages that you're paying to the employee for that paid time off, as well as the employer side portion of the Medicare tax. These payments are exempt from the employer share side of the Social Security tax, so you shouldn't be paying that either, although that wouldn't go into the tax credit amount. And the third component of the tax credit, and this is the one that people often miss, is the allocable portion of qualified health insurance costs that are attributable to that period of leave. That's something that your payroll company might not automatically have. And so if you're relying on them to calculate the tax credit for you, it might be something that's being missed. So make sure you're getting the full tax credit. Okay, next slide. Okay, so what's next? We know it's expired. We know this extension is voluntary extension is only good through the end of March. We have a new administration coming in. It looks like as of yesterday, the Democrats have control over both chambers of Congress. And Biden has certainly indicated support for continuing the Families First law, as well as with some potential expansions as well. So he's discussed expanding the compensation to 100% of wages up to $1,400 a week, so lifting those caps that we talked about. Also expanding coverage to certain non-employees, including independent contractors and domestic workers. So we'll have to wait and see what happens with that. Next slide, please. So that's everything on the federal COVID-19 leave law. With that expiring and only continuing for now on a voluntary basis, that makes the New York COVID-19 law more important than ever. This was enacted March 18th, and it has no expiration date, unlike the federal bill. It also, though, is more narrow than the federal bill. It only provides for leave where the employee is subject to a governmental order of quarantine. There are a few exceptions. One exception I like to call the asymptomatic telecommuter. So if someone's able to work remotely and they're not showing any symptoms, then they're not entitled to this leave. You can require them to report for work remotely. Another exception is employees who voluntarily traveled to a CDC, a country labeled by the CDC with a level 2 or higher health notice, and the travel was unrelated to the employment. After New York started implementing travel restrictions on June 26th, the governor added through executive order an additional exception to the statute, which isn't in the original statutory language, which also prevents employees from taking this if they voluntarily engaged in certain interstate travel. That's prohibited under those, that triggers that mandatory quarantine under the travel restrictions. Next slide, please. So the amount varies by employer size, and for very small employers, it also depends on the net income from the prior tax year. It's important to keep in mind that the amount of paid sick leave under this is based on calendar days, not work days. So if someone works Monday to Friday, and they're entitled to 14 days, that's going to be calendar days. So they're actually only going to get paid for 10 days because in a normal 2-week period, they work 10 days. Unlike the federal bill, this is not funded by a tax credit. This is something that the employers have to pay for out of pocket. So that's another big distinction. Next slide. For private sector employers with less than 100 employees, there's also some expanded paid family leave and disability benefits. Some significant changes are that there's no cap on the benefit weeks when these are taken in conjunction with COVID, and the disability benefit significantly increased. Also, the paid family leave can be taken where the employee or their minor dependent child is subject to a governmental order of quarantine. And these can be taken concurrently, these special expanded paid family leave and disability. Normally, traditional paid family leave and disability cannot be taken concurrently, as I'm sure you know. Next slide, please. So one question that we got a lot in 2020 when these bills were first passed is, how do they relate to each other? You know, if an employee is eligible for leave under both, what do I do? And the New York leave actually provided in the law that it only provides benefits in excess of anything that an employee is entitled to under a federal law. So for 2020, that was really easy. You applied the FFCRA, and then once employees had exhausted that, then you gave them anything extra that they were entitled to under the New York law. But for the beginning of 2021, you know, it poses an interesting question. If an employer voluntarily decides to continue the FFCRA through the end of March, even though they're not required to do that, does that mean an employee's only entitled to the difference still? Or is the employee also going to be entitled to the full amount of leave under the New York law because there was nothing required to give them under the federal law? So that's a novel question and something that we don't have a firm answer to. Next slide. As far as what's next, you know, especially with the expiration of the FFCRA, and if we don't see any movement on that from the federal government to extend it or not extend it on a mandatory basis, there is a bill pending in the New York legislature that would, if passed, fill in some of the gap left by the FFCRA. It would expand the New York paid family leave to cover absences where an employee has to stay home because their child is doing remote learning and they're under a certain age. So that's something hasn't been passed into law yet. at least been proposed, so it's possible that that could get passed. It's possible that New York could take some other action to try to fill in the gap left by the FFCRA. Next slide. It's important to keep in mind with the expiration of the FFCRA and the limited nature of the current New York COVID-19 leave law that there are a lot of other types of law that may apply, especially with the gap now left by the FFCRA. So employees may be eligible for unpaid leave under the traditional FMLA if they have COVID serious enough that it qualifies as a serious health condition, or if a family member does. They may be eligible for traditional paid family leave or traditional disability. They may be eligible to take leave as an accommodation under the Americans with Disability Act or the New York State Human Rights Law. They may be eligible for workers' compensation if they contracted COVID at work. They may be entitled to unemployment benefits, which we'll talk about a bit later, which have been expanded with COVID. And they may be eligible for New York paid sick leave, which we're going to talk about right now. Next slide, please. And next slide. So New York paid sick leave was passed last April, and employers had to begin accruing paid sick leave on September 30th of last year, but employees have not been eligible to actually take paid sick leave until January 1st of this year. So this is going to be the first month where employees have the option to take it. It is important to, when you're thinking about how to comply with this law, to recognize that you can comply by having a PTO policy that complies with the accrual, carryover, and use requirements of the New York paid sick leave law. And we're going to talk through what those are. Next slide. So the paid sick leave requirements for each 12-month period are set forth here. It varies, again, similar to the New York COVID-19 leave law, based on the size of the employer, and for very small employers, their net income. Employees are entitled to 1 hour of paid sick leave for every 30 hours worked. Employers have the option to either use an accrual method and accrue this over time, or to front load it for employees at the beginning of the year. If you do choose the front load option, it's important to keep in mind that if an employee works less than you anticipated, you can't claw back that time. Once you give it to them on a front loading basis, they get to keep it. Now, if you underestimate how many hours they're going to work during a year and whatever you front loaded isn't enough, you're still going to be required to give them the remainder of that time based on those extra hours worked. Employees also have to be permitted to carry over any unused time from year to year. Next slide. The New York Department of Labor has issued proposed regulations on the paid sick leave law. Those are still in proposed form. They're still accepting comments through early February, and we'll have to see whether or not they finalize them. I'm going to go through what those regulations provide, but I did just want to emphasize that they are in proposed form at this time. So assuming these get finalized, some things that they provide are, when you're considering which of those levels you're in and how much paid sick leave you have to give to your employees, your number of employees is determined by the highest number of employees employed at the same time at any point during the calendar year to date. So you're not looking at last year, 2 years ago, you're looking at the present calendar year. So it's possible that you may have 90 employees, and say on June 1st, you cross the threshold and you have 100 employees. And so now you're at that next level. So what do you do? According to the proposed regulations, the increased leave entitlement would only apply prospectively, not retroactively, and that employers may count prior accruals of paid leave and unused paid leave towards those increased obligations, but you cannot count prior accruals of any unused paid leave. You also cannot take away any existing accruals of paid or unpaid leave. So that's what happens if you increase, if you go up a level. If you go down a level, then there's really no impact until the next calendar year. Even though you've now moved down a level, your employees are still going to be entitled to paid sick leave at that higher level for the remainder of the year. Next slide, please. The proposed regulations also clarify that when you're counting employees, you need to count jointly employed workers, part-time employees, employees on paid or unpaid leave, if you have a reasonable expectation that they're going to return to work for you. It also clarifies that when they talk about employees being entitled to 1 hour of paid sick leave for every 30 hours worked, you have to account for partial increments as well. So if an employee works 40 hours, they're not just entitled to 1 hour of paid sick leave, they're entitled to paid sick leave for that extra 10 hours as well. And you can round increments for those less than 30-hour blocks to the nearest 5 minutes, 1/10, or quarter of an hour, provided that that rounding doesn't fail to provide employees with the proper amount of leave over a period of time. So similar to the rounding rules, for those of you who, for your non-exempt employees, track time based on rounded time punches instead of to the very minute time punches. Next slide, please. The New York paid sick leave use requirements provide that you can set minimum increments for employees to use time in, but it can't exceed 4 hours. So you can't require employees to take this in full day increments, for example. But you can use smaller increments. So some companies may use half an hour or 2 hours, and those are all fine. Paid sick leave can be used as soon as it's earned. You can't have a waiting period requirement. You can't say employees can't use this till they've completed 60 days of employment or anything like that. And then the statute also specifies what employees are allowed to use this time for. And it's pretty broad. There's a lot of different issues that can arise with an employee or a family member based on medical illnesses or also routine medical issues, and family member is defined pretty broadly under the statute. Next slide. It also can be used for various domestic violence, family or sexual offenses, or trafficking or stalking issues to permit of the employee or a family member to take certain protective actions, to receive services, to go to court. There's a lot of different issues there. I've listed them all here for your reference. And as mentioned before, you're going to receive a copy of this presentation. Next slide. There are some limitations on what documentation you can require as well. The statute provides that you cannot require the disclosure of confidential information in order to receive the leave. The proposed regulations provide some more information on this. They say that employers cannot require medical or other verification for paid sick leave that lasts less than 3 consecutive previously scheduled work days or shifts. For those that do meet that 3-day requirement, and you can ask for verification, you still can't ask for confidential information, and you can't require employees to pay any costs or fees associated with getting that medical note or some other form of verification. You would have to reimburse them for that. Next slide. Employers also have a record-keeping obligation. They have to track how much paid sick leave their employees have used and accrued in the current calendar year and in any prior calendar year. If an employee asks you for that information, you have to provide it to them within 3 business days. Next slide. The statute also includes some provisions about collective bargaining agreements, offering a bit more flexibility for companies with collective bargaining agreements. However, if you're going to take advantage of these, you do need to make sure that the collective bargaining agreement acknowledges the provisions of the specific law. So you would want to reference the law in that bargaining agreement. Next slide. Okay, so what's next for paid sick leave? Well, we have the new law in New York. For those of you with New York City employees, there's also the New York City law, which has some different twists to it than the state law. So they're not completely the same. And you would need to comply with both for New York City employees. Also, on the federal level, Biden has indicated his support for up to 12 weeks of paid FMLA leave and up to 7 days of paid sick leave for routine personal and family health needs, as well as certain domestic violence and assault issues as well. So we may see some federal legislation on this. Next slide. Okay, I'm going to touch quickly on travel restrictions. Next slide. There have been numerous iterations of this throughout the year. We used to be getting weekly lists of states that met certain statistical criteria, and then as the list of states continually grew bigger and bigger, and it pretty much was almost every state in the country, they switched it, and now the current restrictions apply to travelers to non-contiguous states, so those that don't border New York, as well as US territories and countries with a CDC level of 2 or higher. There's a mandatory 10-day quarantine, but there is the option to test out. The employee would need to test 3 days prior to arrival or within that 3-day period prior to arrival in New York, quarantine for 3 days after arrival, and then test on the 4th day after arrival. If both the tests are negative, then they get to exit quarantine early. Next slide. There are some exceptions. So travelers who are out of state for less than 24 hours don't need to get that test before returning to New York, don't need to quarantine upon arrival, but they still have to get a test 4 days after they get back. There's different rules for first responders and essential workers, depending on the length of their stay in New York. But for your employees, I'm going to assume that they're fall into the category of staying in New York for 36 plus hours. So they would need to seek a test on the 4th day after arrival in New York as well. Next slide. Unemployment. Next slide. There have been a number of developments on unemployment over the course of the year. First, the CARES Act dramatically expanded the eligibility requirements, extended the benefits period by 13 weeks, so 39 weeks total, and increased the benefit by a flat $600 per week through July of 2020. Trump issued a memorandum which provided a temporary extra payment as well until the funding for that ran out. And in the latest COVID-19 relief bill, which was passed at the end of December, it extends the expanded eligibility requirement. It extends the benefits period by an additional 11 weeks, so 50 weeks total, and it increases the benefits by $300 per week through March 14th. It also has an extra benefit of $100 per week for certain workers who have both wages and self-employment income where their benefits calculation doesn't account for that self-employment income. Next slide. Okay, so just a quick note on voting leave on the next slide is in 2019, New York revised its voting leave law quite significantly. And then in the April 2020 budget legislation, they reverted back to the old voting leave laws effective immediately. So you should have seen this change and implemented this change for last November's election. But just for those of you who may have missed it, we have gone back to just 2 hours of paid time off to vote, and it's only required where employees don't have sufficient non-work time to vote. And then they have to give you notice within 2 to 10 working days before the election. And so that is the conclusion of my portion of the presentation. I'm going to turn it over to Joanna.
Thank you, Kate. Happy New Year, everybody. Glad to be with you today to give you an overview of developments that occurred in 2020 in the employment-based immigration field between the election and between the pandemic. It was a bit of a crazy year when it came to employment-based immigration. I'm sure that many employers and practitioners will tell you that we suffered whiplash on more than one occasion during the course of the year. So I'm going to try to give you a brief overview of what's occurred in 2020 and what we can expect possibly in 2021. Some of the major developments that we saw in 2020 were presidential proclamations that set forth various border restrictions. We saw various changes to the H-1B policy and procedure. There was a public charge rule that went into effect, then was not in effect, that was in effect, and then not in effect. It kind of went back and forth for a little while there during the course of the year. And I think there's still a question as to whether or not there'll be further developments before the end of the Trump administration. However, given the president's priorities over the last few weeks, at this point, we think it's a little unlikely, but there still is obviously some time remaining and the possibility for additional changes. Next slide, please, Kathy. So mostly due to the pandemic, one of the major developments that we saw this year were various border restrictions that went into effect essentially from the start of the pandemic. And this immediately posed a challenge to employers looking to hire international workers. The current presidential proclamations that went into effect pertain specifically to China, Iran, the Schengen countries, the UK, Ireland, and Brazil. The general rule is that individuals who are in any of these countries in the prior 14 days before they seek entry into the United States may not enter the United States. So it doesn't pertain necessarily to citizens of those countries, but any individuals who are in those countries within the prior 14 days will not be able to enter the United States. One workaround that we advised clients on this year was essentially if you had somebody who was a UK employee, for instance, we recommended that they go to an unaffected country and quarantine there for 14 days and then seek entry into the United States on the 15th day. Although this was probably a little bit more frustrating than expected, at least it was a way to get people into the United States if it was an absolute essential to the start of their employment. There are various exemptions with respect to this proclamation. For instance, US citizens or lawful permanent residents returning to the United States are not subject to these presidential proclamation, and neither are spouses of citizens or lawful permanent residents. The Department of State has issued several national interest exceptions. Some of them are automatic. For instance, students, there was a national interest exception across the board for incoming F1 students who otherwise would have been subject to these presidential proclamations. And other individuals can receive national interest exceptions, but they're completely at the discretion of the embassy in the country where they are, and they're not automatic. And I can tell you that it's been a somewhat frustrating experience with respect to obtaining these national interest exceptions. We have had success for some individuals, but others, we definitely have received challenges on. So it's important to know that it's something that can be attempted, but it's not something that is absolute. It's completely at the discretion of the embassy. Currently, these proclamations are all in effect, and according to the proclamation, they're in effect until terminated by the President of the United States. So in terms of what will Joe Biden do, I think it's to be determined. I mean, chances are, knowing what his attitude is towards the pandemic, I think that he'll look at the current statistics regarding the spread of COVID and do what's necessary in order to stop, to contain the spread. So this is something we'll keep our eye on, especially as we ease into the new administration. Next slide, please. So in the midst of the pandemic, there were two other presidential proclamations that were issued by the president during this time. One of them was to suspend the entry of certain H, J, and L non-immigrants into the United States. And this went into effect on June 24th. And it was set to expire on December 31st, but on that day, President Trump issued another proclamation extending this proclamation through March 31st, 2021. So it's still in effect, and we'll see what Biden does with that once he comes into office. The basis for this proclamation was that allowing individuals to come in H, J, and L status and work in the United States would present a risk to the US labor market following the effect of coronavirus and the jobs lost and the unemployment rate as a result of the pandemic. So that was the motivation for this proclamation. And this was definitely very difficult with respect to US employers, colleges, universities, and other industries who really use, especially the H visa, to employ individuals in the United States. There are different exceptions. I mean, this proclamation only applies to individuals who were actually outside the United States on the effective date of the proclamation, June 24th, who didn't have a visa in their passport that was valid, an H, J, or L visa, or who didn't have another official travel document that was valid as of that date, like advance parole. There are general exemptions from this requirement, including obviously, people who don't qualify for those non-immigrant bases, and there are also non-interest exceptions available. So again, this didn't apply to people in the United States. That was probably the number one question we received from clients, whether or not this affected current H-1B visa employees in the United States. It did not. It applies specifically to those individuals outlined here in the slide. So this one we'll also keep our eye on. It's currently valid till March 31st. Joe Biden, when he comes into office, he can either revoke it or modify it or supersede it. So we will have to keep our eye on that, and it will definitely provide updates as those come in. Next slide, please. This proclamation basically went hand in hand with the prior proclamation, even though it was issued a couple months earlier. This is a similar proclamation limiting the entry of certain immigrants into the United States. When we say immigrants, we are speaking about people who have permanent residence or a green card. The same rationale was used for implementation of this presidential proclamation, essentially that these individuals would present a risk to the US labor market as a result of the conditions created by the coronavirus. In a similar vein, this applied to individuals who were outside the United States on the effective date of the proclamation, April 23rd, 2020, who did not have an approved immigrant visa as of that date, and who did not have an official travel document other than a visa that was valid on April 23rd, 2020. So again, this did not pertain to individuals who were in the United States. This was essentially individuals who were in the permanent residence process, mainly outside the United States. Originally, this prohibition was going to be in effect for just 60 days. Then there was another proclamation, I want to say in about June or along those lines, that extended this proclamation through December 31st, 2020. And then in the same presidential proclamation that extended the prior restriction with respect to HL and J non-immigrants, President Trump also extended this proclamation through March 31st, 2021. Same rationale. We'll see what will Joe Biden do when he takes office. Again, he can modify it, he can eliminate it. So we'll have to see what his tactic is once he comes into office. Next slide, please. I wanted to say a word about Canada and Mexico border restrictions. We do have a number of clients who cross the borders for various work-related or education-related matters. Basically, since March, an individual can only enter the United States by land, by ferry, or by passenger rail for essential travel. This restriction remains in effect. It's still valid through January 21st. We think it probably will be extended. This seems to be extended mostly on a month-to-month basis. But there are a lot of exceptions. Essential travel, people can come to the United States. Obviously, if they're a United States citizen or a lawful permanent resident returning to the United States from either Canada or Mexico. Individuals who are traveling for medical treatment or traveling to attend educational institutions in the United States, or traveling to work or engage in lawful cross-border trade. These are various examples that would qualify for essential travel in order to travel between the United States and Mexico or the United States and Canada. There are more exceptions, but I just wanted to give you a flavor for some of the exceptions with respect to this restriction. Next slide, please, Kathy. So the other item that I mentioned where we saw a lot of activity this year was changes with respect to H-1B policy and procedures. And I would say the Trump administration worked pretty hard to make a lot of different changes to this program. Some were good, some were bad, some stuck and will be around for time to come, and some didn't. So I wanted to go over a few of those items, one of which is timely as we enter the H-1B visa cap season regarding registration for the annual H-1B visa cap. There were also regulations proposed by the Department of Homeland Security and the Department of Labor with respect to H-1B visas and changing prevailing wages for labor condition applications. And we'll talk about those as well. Next slide, Kathy. As I just mentioned, one of the developments that came about in 2020 was a new registration requirement for annual H-1B visa cap filings. And this is a timely discussion because H-1B cap season is upon us. There's no official word yet, but we believe that registration will continue this year and it'll probably begin in March, which is the same time that it began in 2020. For those of you who are involved with the H-1B visa program, as you know, prior to this last year, the way the H-1B cap season worked is that employers would file complete petitions on behalf of potential H-1B visa employees with the hopes that their petition would be selected and counted against the H-1B visa cap, either as one of the 65,000 under the regular H-1B visa cap or one as part of the 20,000 master's cap visas. And that would take a lot of work. Attorneys, employers would prepare complete petitions, submit them, and then there would be a lottery that would occur during the first week of April. And if your petition wasn't selected, it would be returned to you. So it became a very costly and very time-consuming process for employers. Earlier this year, the Immigration Service implemented an H-1B visa registration process where employers could register and pay $10 per beneficiary to register, so essentially throw their hat in the ring to be selected to file an H-1B visa petition. So this was a better option, I think, because employers did not have to file the petition. As part of the registration process, they just provided basic information about the beneficiary and the position to be held. And the lottery would still be held, but if you were selected, you were then given 90 days in which to file the petition. So this, even though you're still subject to the lottery, at least a lot of the legwork did not have to be done up front. You would only prepare and submit a petition if your registration was selected by the Immigration Service. So I think overall, I think most employers and most practitioners would tell you that this was probably a welcome change, given the fact that it definitely decreases the amount of paperwork and legwork done for H-1B visas, and there probably is an overall cost savings for employers. So I think most people would like to see this continue, but we don't have official word from the Immigration Service as of yet. Next slide, Kathy. These rules, I'm just gonna fly through a little bit because they're thankfully not in effect. But two other developments that occurred this year: the Department of Homeland Security had proposed rules back in October, making the definition of specialty occupation much more strict and restricting employment of H-1B employees at third-party work sites, and also to shorten the visa term from 3 years to 1 year. Had this gone through, this would have drastically changed the eligibility criteria for H-1B and really would have made the program recognizable. There was a number of proposed actions that would have changed the program as we actually know it. Thankfully, the rule was struck down. I have here on December in a federal court in California, but it was actually struck down by 3 separate federal courts. On the basis that the Trump administration did not follow the legally required notice and comment periods required by the Administrative Procedure Act. So there was some discussion in December that they thought the case would be appealed by the Trump administration. That hasn't occurred yet. It's probably unlikely under the current circumstances and the remaining time left in the Trump administration. But keep our eye on it for the next couple of weeks, just in case. Next slide, please. This rule, the Department of Labor also had proposed regulations regarding the prevailing wages that are used as part of the H-1B visa process and also part of the PERM labor certification process in the green card arena. This rule was a little bit different. It basically went into effect as soon as the rule came out. So back in October, employers had to scramble. What the regulation did was that it increased prevailing wages that are issued by the Department of Labor by 40 to 50%. So for instance, if you were hiring somebody and the prevailing wage for the job was $100,000 under the prior DOL regulations, under the new prevailing wages issued by the DOL, all of a sudden the prevailing wage for that job could be $150,000, which would put employers in the position of not being able to hire individuals at these wages. Nonetheless, in early October, employers had to pivot immediately and start using the new wage data that was issued by the Department of Labor. So this was a huge change to the H-1B process and the labor condition application process that's part of that process. Thankfully, as part of the same litigation regarding the prior rule, in December, the rule was struck down also by 3 federal courts. And the good news was that the existing prevailing wages were restored by the Department of Labor. So there was a lot of whiplash going on for employers with respect to getting these applications filed with the new wage data, but thankfully that's not an issue, and we're back to the wage data that's issued annually by the Department of Labor. Kathy, next slide, please. Public charge rule, all you really need to know about this is that it's currently in effect in most regards, and this affected the way that individuals can be, how the Department of Homeland Security and the Department of State determines whether applicants to the United States should be denied because they might become a public charge and be inadmissible in the United States. I could spend about an hour or more talking about this. There's also been a lot of whiplash with respect to this rule. It was in effect, then it wasn't in effect, then it was in effect. And it involves a whole slew of new paperwork, a new process, and there's a lot of controversy around it. President Biden, I know that he has said that within the first 100 days, this will be gone. So for the time being, it may apply with respect to various petitions that employers are filing, but we don't expect the shelf life to be much longer. Next slide, Kathy. So in general, what to expect in 2021, I think with the incoming administration and the fact that Democrats are in control of both houses of Congress, we're going to see employers will have broader ability to bring talent to the United States. We're hoping that the tone, policies, and procedures are going to be more favorable to employers than they've been over the last few years, and that there'll be less challenges to cases by the Immigration Service. We expect to see a lot of undoing of President Trump's executive orders and presidential proclamations, including the Muslim travel ban stemming way back to 2017, and the various travel restrictions that I mentioned during this presentation. I think we'll see more to come on DACA, possible path to citizenship, among others. So it should be interesting as the year gets started. And on that note, I'll pass it on to my colleague, Lou DiLorenzo.
Thank you, Joanna. Okay, I'm going to wrap us up with some of the national labor policy situations that occurred during the year and where they're headed for the future. Sorry about that dog. He's a COVID dog, and he gets worked up during webinars. So the first slide we have, you see deals with the composition of the board. So we are for a short time going to continue to have a Republican majority on the National Labor Relations Board, which sets our national labor policy. That's going to exist. There's one vacancy. There's one Democrat in office now. The next Republican's term is up. It's Mr. Emanuel's term, which is in August. Obviously, President Biden will appoint a Democrat at that time, and the board will then have a 3-2 majority Democrat over Republican. That's when the changes will really start in earnest. Next slide, please, Kathy. These are some of the changes you're going to see. These are recent landmark decisions coming on the eve of 8 years of President Obama's NLRB, which reversed some of the decisions they reversed were 75 years old, 85-year-old precedents. These decisions are fairly recent, last year or the year before. And, we've been experiencing through 2020. One is Apogee Retail, which allows a certain degree of confidentiality in workplace investigations, pretty low standard, something that the EEOC has strongly recommends in sexual harassment cases, for example. So part of the reasoning for this decision was to bring it in line with modern employment law that's recommended by some of the other federal agencies. Caesars Entertainment was a culmination of a long list of the balancing that has gone on since 1935 in terms of assets of the employer, whether it's real property, a building, telephone systems, and of course the modern equivalent of the water cooler area, which is employer email. And basically in Caesars Entertainment, balancing the interests of employees to be able to organize with the property interests of employers to have interests in the assets that they purchase, buy, pay for, make available for work use. How much do they have to allow those to be used by employees or even outsiders who were interested in organizing the employees. So Caesars Entertainment cut back substantially on the President Obama's board decision concerning the use of employer email. The MV transport case was a very significant case, didn't get a lot of attention, but a significant case in terms of not requiring that a contract have a clear and unequivocal waiver in order to give the employer the power to do something unilaterally. They use the same contract standard as everybody else uses to interpret contracts. The question is, did the union give up the right in that contract to stop an employer from doing something? If the employer had the right to do it, then the employer could do it unilaterally without bargaining. The long-standing rule in the NLRB was that in order to have a unilateral right to do something, there must be a clear and unequivocal waiver setting forth the employer's right to do that. For example, a specific provision that said the employer can change work schedules on 2 weeks' notice. A broad management rights clause that said you have the right to direct the plant and the employees, and a past practice of changing work schedules would not have been sufficient in the old days to constitute a clear and unequivocal waiver. Now, in my opinion, it would be. If the contract says you can direct the plant, its operations, and you have a past practice or bargaining history of having the right to change work schedules unilaterally, then you have the right to do it, even though there's no clear and unequivocal waiver in the contract. So you see these cases, Johnson Controls, Boeing, dealing with the illegality of company policies under the President Obama administration. A policy could be illegal on its face, or even if it would unreasonably chill an employee, although it never been applied that way and didn't say that, if an employee could interpret it as chilling their Section 7 rights, it was an illegal policy. The Boeing case deals more with the reality of what does the policy say and how is it applied by the employer. And there were 3 categories of potential rule evaluation, category 1, 2, and 3. Valley Hospital Medical Center was another important case that talked about whether you could have a dues checkoff provision exist and survive contract expiration. Those of you that have negotiated contracts know that oftentimes after a contract expires and the negotiations are stalled, oftentimes what the employer has done is to stop the dues deduction provision. The clause expired. And therefore the dues deduction stopped. That oftentimes, or the threat to do so, would encourage the union to get reasonable at the bargaining table and perhaps reach a settlement. The Obama board indicated that those clauses do not survive contract expiration. Valley Hospital Medical Center restored the old rule. You can expect that you can take the general counsel's memos of the cases, Peter Robb's memos under the President Trump board, his list of things that he thought they should review that had been changed by the Obama administration. I think you can take that list and reverse it and say these are the rules that once the majority of the board becomes Democrat under President Biden, you will see a reversal back to those days. In addition to what's going on in the world of organizing, during COVID, I think a number of things have changed in 2020. There has been a great deal, in my opinion, of organizing activity and bargaining activity by the unions. One of the things I think that's fertile ground for unions is when people are concerned about change and uncertainty. And obviously COVID provided both of those. There's severe job security. I just saw again today that we had a record number the number is still high, 700,000, 800,000 new filers for unemployment insurance this week. There is a great deal of unemployment, creating uncertainty. There is uncertainty concerning the safety of working. There will be vaccine questions that unions get involved in. All these things, all this environment of uncertainty creates an opportunity, frankly, for people to turn to a union where they believe they may be able to get some protection or added protection in terms of safety, security, and other things. I think that unsettled and unsecure ground upon which things stand create the opportunity, and I've seen the opportunity exercised and grabbed a hold of by another number of employees. Recently, we saw an incredible phenomenon, I think, on the spectrum of union organizing, which is a group of about 230 employees at Google announced that they had formed a union called, I think, the Alphabet Workers Union, Alphabet being Google's parent company. It's affiliated with the CSEA, Civil Service Employees Union, which has about 700,000 members nationally. CWA, I'm sorry, I don't know if I said CSEA, CWA, Communication Workers of America. So this union was not formed under the auspices of the NLRB. There are 123,000 employees at Google. This 230 employee unit signed up as a minority union, a phenomenon that we've seen talked about in literature. A very well-known professor and arbitrator at Cornell ILR School, James Gross, wrote a book about this 20 or 30 years ago that frankly didn't get a lot of attention, but it may now. But the idea of minority unions and perhaps an employer having more than one minority union to deal with, since a majority wouldn't be required and a majority would not have exclusive bargaining representation on behalf of the employees. They've said that this group, which was announced at 230 and less than 24 hours later had 400 members and is expected to grow into the thousands, has stated that it's not about negotiating a contract in the typical terms with the employer. It's not about trying to argue over what type of tea will be available in the free lunchroom at Google. It's interested in dealing with all the issues that Google is involved in. It's a fight over power to talk about what Google will build, how it's going to treat people, whether certain parts of Google should even exist. And one of the things that's going on is there's about 100, I said there were about 123 full-time Google employees. There's 130,000 contract employees, temporary workers, who are not eligible to join the same union as the full-time employees. And so this minority union provides an opportunity and a voice for those people as well. They've identified pay equity issues, sexual harassment issues, a number of social issues that they want to be heard and be involved in. The predictions are that Facebook, Amazon, and Apple, huge companies, will also be facing this threat of minority unions. This will change the landscape greatly. We expect President Biden, because of the support he received from organized labor and incredible political and financial support from organized labor, we expect to see a great deal of support for the union. President Biden throughout his career has been a big supporter. Continuing the President Obama theme that a middle class needs a union, and somehow that a union, which in my opinion doesn't create jobs and doesn't create wealth, will somehow create a middle class in the United States. So stay tuned. I think that organized labor is in a very good spot right now to change the law. As you can see from the last slide, Kathy, there's a bill that the Democratic platform has indicated they will support. And if President Biden has the support in the House and the Senate, which it appears that he does, there's a chance this bill could actually pass, which would be the most far-reaching labor reform that's occurred since 1935. It does so many things. This is a list of some of the things that it will do. Permit secondary boycotts, repeal right to work, the right states to be able to pass the right to work provisions they currently have. It would preempt the field and prohibit that. Perhaps the new statute would prohibit hiring permanent replacements during a strike, prohibit mandatory arbitration in non-union setting, permit a private right of action for violations of the National Labor Relations Act, not just unfair labor practices. So it's a total revamp. In my opinion, it's a good time while we're talking about vaccines This is a good time for non-union employers that believe that it's important that their operations continue to remain union-free, that they perhaps do an audit of their current situation, see where they're vulnerable in terms of policies, rules, or situations, or particular departments or demographic areas within their organization, training, communication, all the steps that normally you would take to create a positive employee relationship and communication system with your employees so that employees would not embrace a union as being needed. Those are things that can be done on a proactive basis. So I'll stop there and wish you all good luck in 2020 on behalf of all of us here at Schoeneck King. Take care. Thank you.
This is Kate McClung, just circling back. There are a few questions. I've tried to answer some directly in the Q&A, and there's a few more I'm going to address now. I'm sorry, I'm not going to have time to get to everybody's, but for those of you willing to stay an extra few minutes, I'm going to address the questions that multiple people asked and prioritize those. So for the New York paid sick leave, this does apply to private sector employers. Some of you asked about the front loading option for how does that work for employees who are working just a partial year or for part-time employees. The statute talked about front loading all leave that would be required under this statute, which could be interpreted as you have to front load the entire amount of the leave for everybody, or it could be interpreted as you just have to front load the amount of leave based on how much you think the employee is going to work. But the New York Department of Labor has issued some informal guidance, and it appears that the position they're taking is you would have to front load all of the leave for everybody, regardless of how many hours you think they're going to work. They haven't provided guidance about how this would work for people who aren't starting at the beginning of the year, if there is the option to prorate there or not. That's something that we don't know. If you would like to know, I would encourage you to submit comments to the proposed regulations and ask the New York Department of Labor to clarify this issue and a number of other issues that we still don't really have a good answer on this new law. Another question I got about front loading was, if I front load, do I still have to carry over? There are some paid sick leave laws in other jurisdictions that provide if you front load, you don't have to carry over. Unfortunately, the New York State paid sick leave law does not include that exception, and that exception is not included in the regulations or in the informal guidance. So it does appear that even if you're front loading January 1st or the beginning of whatever your 12-month period is, that you would still have to permit carryover. Finally, I got a number of questions about the New York COVID-19 leave law. It provides for a certain number of paid sick days. Is that just one bucket, or do you have to provide that number of days for each order of quarantine? And this is something that is an ambiguity in the statute. It is unclear, and the state has not clarified this in guidance, whether it's one bucket or whether you have to provide that amount of paid leave for each order of quarantine if you do have an employee who's subject to multiple orders of quarantine. The only area where we've gotten feedback on this is with respect to healthcare workers. The New York State Department of Health and the New York State Department of Labor issued guidance most recently on June 25th of 2020, clarifying that healthcare workers max out of this leave after 3 orders of quarantine, and there's certain requirements that would have to be met for them to receive this leave for the 2nd or 3rd order of quarantine as well. So for those of you with healthcare employees, that provides you with a bit more information, but it's still unclear in other contexts. So I'm sorry I can't give you a firm answer on those issues, but that's the current state of the law, and hopefully the state will provide us with some more guidance. Okay, and I think that is, I don't think there were any questions for the other sections of the webinar, so thank you all so much for attending. If you do have questions that we weren't able to get to today, I do apologize, but I would encourage you to reach out to your favorite bond attorney for those.
Thanks, Kate. I just want to take a moment and remind everyone that we will be emailing the certificates of attendance for HRCI and SHRM recertification. And that email will also include a copy of today's presentation handout. So on behalf of Lou, Kate, and Joanna, thank you so much for joining us, and have a happy, healthy new year. Take care, everyone.